Welcome to Office Hours with Peter Hannock. Today I want to talk about a number of concepts. First, the distinction between factual and legal guilt. Second, the idea of the presumption of innocence and how that applies in the American criminal justice system. And third, the case of Darren Wilson and Michael Brown. So to begin with, this idea of factual versus legal guilt. This is a topic that my students always find difficult. I bring it up in class and then they say, okay, I get it. And then I ask them to explain it to me and they're like, oh, maybe I don't get it. And we often have to kind of go through it a couple times until everyone really feels comfortable with it. But the basic idea between factual and legal guilt is, factual guilt is, did you really do it? Whereas legal guilt is, do we feel comfortable as a society saying that we're going to find you guilty? In the same way of factual versus legal innocence, factual innocence is you didn't do it, and legal innocence is we found you innocent. Okay, so everyone seems like they get that, right? Okay, well, let's kind of tease it out a little bit. And to do that, I'm going to use an example, which I'm always kind of reluctant to bring up because it's controversial in itself and it starts a debate that I don't necessarily want to have, but I'm referencing it because it's one that I think everyone's familiar with and people kind of get. And that's the case of O.J. Simpson. So O.J. Simpson, as I'm sure everybody knows, but just to briefly recap, was tried for the murder of his ex-wife, Nicole Brown Simpson, and her boyfriend, Ron Goldman. And the consensus that we've reached, I think, is that factually, he probably did it, right? We've kind of reached that idea that he probably did it. I mean, a couple years ago, he actually wrote a book which was titled If I Did It, right? Where he kind of laid out how he did it. So there we can say, okay, so factually, he's guilty. But was he found guilty? No, he was found innocent. He was acquitted. So the jury found him not guilty. So this is a case of, and again, just if you disagree, that's okay, but let's run with the idea where we say factually he did it. He really did it. He really killed those people. But legally, the jury decided that there wasn't enough evidence to convict him. So they found him innocent. They acquitted him. They found him not guilty. In the same way, we could imagine someone who was wrongfully convicted, right? Someone, and if you're interested in this topic, the Innocence Project has devoted the last decade or two to trying to track down these cases using DNA evidence to exonerate people who were convicted wrongfully of crimes. And the evidence comes out after the fact that they didn't actually do it. So in that case, we would say factually they were innocent, but they were found guilty. So our ideal situation, and what we'd hope most of the time happens, is that people who are factually guilty are found legally guilty, and people who are factually innocent are found legally innocent. But we recognize that mistakes happen, and the two kinds of mistakes that can happen would be someone who is factually innocent but found legally guilty, and that would be a wrongful conviction, or someone who is factually guilty but found legally innocent. Now, if this all sounds very obvious to you, my apologies. I'm not trying to talk down to anybody, but I am trying to be really clear about these ideas. And what's really difficult and what's really tricky sometimes is when we make a claim legally, when we say that someone is guilty legally, we are not making a claim factually. We're not making a fact kind of claim about the world. We're making a legal claim about the world. And the same way when we say someone is legally innocent, we're not saying, oh, and therefore we know with certainty that they didn't do it. Rather, we're saying that in the eyes of the law, given the standards that we have and the law that we have, there is not enough evidence to convict this person. And the saying in the American criminal justice system often is, we would rather have 10 guilty people go free than one innocent person go to jail. And built into that, or what stems from that, is the idea of the presumption of innocence. And when I say the presumption of innocence, where I think what sometimes gets confused here is the presumption of legal innocence, not the presumption of factual innocence. To a large degree, the law is kind of agnostic about what really happened. The courts are not scientists. The courts are not philosophers. Courts are a way for a society, in a case of a country like the United States, for a way for a democratic society to express its either decision that there's enough evidence to find this person guilty and therefore to punish them, or that there's not enough evidence and therefore we're going to let this person go. And the way that the presumption of innocence works is that, and again, I'm trying to avoid oversimplifying things too much, but the basic idea is ties go to the defendant. If you're not sure which way to go, the defendant wins, because that's where we're going to put our thumb on the scale. Because we as a society recognize that the rights of the accused need to be protected, and we as a society have come to the decision that we would much rather guilty people go free than innocent people go to jail or innocent people be punished. So how does this work with this idea of legal innocence versus factual innocence? Well, part of this comes down to, like, how do we know things? So in philosophy, there's this entire branch of philosophy called epistemology, which is related to the knowing of things and how we know things and how we gain knowledge. And then obviously in science, we have an entire method that we use to say that we know things. Now, those of you who've heard my videos before or have taken any science class kind of know the idea that scientists and those who employ the scientific method, we are always really reluctant to say that we know things. That's not the way we usually speak. We don't speak with that kind of certainty. There's very few things that we're very confident in that way of saying that we know. So what kinds of things can we know? Well, one way we can know things is by definition. We define a foot as 12 inches. We've defined it, therefore it's a fact. We defined that fact, and therefore it's kind of true because we said it was true. Then there's also the way that we can kind of know things by the way that we approximate or try to measure or try to understand the world. And that's where we use the scientific method. And that idea of making observations about the world, making a guess about what we think is right, figuring out some way of assessing the accuracy of that guess through an experiment, through a test, through a measurement, then saying, okay, if results of the experiment seem to support our guess, then we say, all right, we can move from hypothesis to theory. And then we invite our colleagues to come in to see if they can replicate that finding. And if enough people replicate it, then we start to say we're pretty confident in it. But notice that in science, we don't talk about certainty. We talk about confidence. Right? We don't say that we are definitely sure that this is the case. We say that we are confident that this is the case. And in the case of statistics, for example, we tend to put confidence intervals around things to say plus or minus, right? We say that this is our best guess, plus or minus a few percent. And in this way, scientific knowledge is probabilistic. It's not certain. We say that we are fairly sure. We are pretty sure. And sometimes we'll actually give a probability attached to it to say, this is how sure we are. And then, of course, the thing about scientific knowledge is that it's always contingent. Scientific knowledge, insofar as we have knowledge, is always waiting for another experiment to be done which provides us evidence which might make us throw out our old theories, or at least have to revisit them and figure out ways of incorporating those new findings, incorporating that new data. The law is different. The law doesn't have a scientific method like that. And the law is certainly not, we're not a bunch of philosophers when we engage in the law. So what do? Well, we set up burdens of proof. And the three common burdens of proof, which you might be familiar with, would be probable cause, propensity of the evidence, and beyond a reasonable doubt. Probable cause is, and to be very clear, we can't really attach percentages to probable cause, but we just feel like there's enough evidence that we feel like, okay, there's a good case to be made that someone did it. Or we say there's not enough evidence that someone did it. Now, when we say that, we're not saying that they factually did it. We're saying in the eyes of the law, there is not enough evidence to say that they did it. So, is it possible for someone who is factually guilty, like they did it, not to meet the level of probable cause? Of course. Of course that's possible. Of course it's possible that for some reason that arrest is not going to be valid because there's not enough evidence to support it, so you don't get a warrant. In the same way, we also, in civil court, we talk about the propensity of the evidence. And the propensity of the evidence is this kind of, think of it like a 50-50 scale. If it's 51-49, that's the propensity of the evidence. That means that there's slightly more evidence that someone is negligent or someone is liable than that they're not. So they lose because there was slightly more evidence. And in the criminal law, that burden of proof, in order to convict somebody, is beyond a reasonable doubt. And here you're going to ask me, like, what's the percentage for beyond a reasonable doubt? Is it like 75%? Is it 99%? And here I'm going to do that professor thing or that lawyer thing that people don't like. And I'm going to say, like, we don't know. People have tried to nail down a percentage, and every time a judge will try to give a percentage to the jury, guess what? That case is going to get appealed, and you know what? If the jury acted on that instruction, that case is going to get overturned, or at least it's going to have a new trial, because the Supreme Court has held consistently that when we say beyond a reasonable doubt, you can't give a percentage to that. Okay, but what does it mean? It means that definitionally, there's no case in which we think, like even the slightest chance that they didn't do it. Because if we think that there's the slightest chance that they didn't do it, then you have to acquit. If there's even the slightest chance they didn't do it, then you have to find the person not guilty. And we say not guilty, we mean not guilty as a matter of law, not that they're innocent as a matter of fact. Okay, so how does this relate to Darren Wilson and Michael Brown? So this is a question I actually got a lot of feedback on in my comments to Sam Harris's podcast, episode 207. In my response, a lot of people wanted to really relitigate and talk about that case, the killing of Michael Brown at the hands of Darren Wilson, the police officer in Ferguson, Missouri, and the question of what that case represents and what it means. And a lot of folks really wanted to debate my credentials and ask about, my qualifications for the way that I characterized that case. And so I'll be really clear here, and I've never tried to pass myself off as a crime analyst or a forensic analyst, right? Like, I do not, as a job, look at DNA or fingerprints or anything like that. That is not what I do. As a criminologist, we're not really interested in, that's it's certainly related to crime, and it's related to criminal justice. And in some universities, both of those two things will happen in the same department. But generally speaking, criminology is distinct from criminalistics, or that kind of forensic analysis, that kind of CSI stuff. To be very clear, I am not trying to pass myself off as a DNA expert. But I have looked at that case a lot. Read a lot of that case. I read over all of the grand jury evidence, all the transcripts, all the testimony. I looked over the evidence. I've read the Department of Justice's findings, both the Ferguson report, that was about the city of Ferguson and the Ferguson Police Department, and the Department of Justice report regarding Darren Wilson's actions and whether they were justified. And here's where I think that there's a lot of confusion. Okay, so I want to be really clear about what happened in that case, and also what didn't happen. A number of people have said, well, wasn't Darren Wilson exonerated? Wasn't he found not guilty? Wasn't he acquitted? And the short answer is no. Why? Because there was never a trial. There was never a trial, so there never was a jury who found facts. Because in the American criminal justice system, it's the jury that finds facts. There never was that. So what was there? Well, there was a grand jury, and the grand jury made the decision whether the case should go forward or the case should stop. And the way the grand jury makes that decision about whether to go forward or whether to stop varies from place to place, from jurisdiction to jurisdiction. And to be very clear, the grand jury that happened in Ferguson was really, really weird. That's not the way that most grand juries work. The old saying, the cliche, is that a grand jury will indict a ham sandwich. Usually the burden of proof for grand juries is very, very low, because the only thing the grand jury is doing, and the criticism of grand juries is that it's often just a rubber stamp, that whatever the prosecutor wants, the grand jury will sign off on. What happened in Ferguson, what happened with Darren Wilson's case, was really interesting, because it was almost like a trial. There were hundreds of pages of testimony, hundreds of pages of evidence that the grand jury had to evaluate. And which is, again, not usual. That's not normal. It's not usually what they do. And in the end, the grand jury decided not to indict. which is not the same thing as acquitting, which is not the same thing as exonerating. Rather, what they said was that the evidence was not sufficient for the case to go forward. Now here, I can hear, right, a lot of you saying, doesn't that mean he's not guilty? And this is where I want to come back to this distinction. It means in the eyes of the law, there is not enough evidence for the case to move forward. It means in the eyes of the law, there's not enough evidence to say that he should stand trial or certainly that he should be found guilty. What does that mean about whether he really did it? Not a lot. And this is where I think sometimes this gets confusing. When we say that the jury makes a determination or the grand jury makes a determination, they're not making an epistemic claim in the philosophical sense about like knowledge and what is true and what things' essences are. And they're not making a scientific claim where they're saying probabilistically we are this confident that this is the case. Rather, what they're saying is whether there is enough evidence to meet that legal burden of proof. And if there's not enough evidence, then we will say, okay, we're going to balance those kind of he said, she said uncertainties in favor of the defendant. And to be really clear, I'm supportive of that. Like in a past life, I worked in criminal defense. I worked on criminal cases representing indigent defendants. I'm very supportive of the presumption of innocence. I think the presumption of innocence is very important. But I will also say, as someone who represented a lot of people who I was pretty certain did it, as someone who worked on cases where I was pretty certain the person did it, that the issue is not whether they factually did it, but whether the state has met its burden of proof, has met its evidential burden enough where we're going to say, oh, we should find this person guilty. Was Darren Wilson acquitted? No. Was Darren Wilson exonerated? No. What happened? What happened was the grand jury decided there wasn't enough evidence. Now, here's where you're saying, okay, well, doesn't that mean he didn't do it? Or at least he probably didn't do it. And this is where I want to get into the idea of what kinds of evidence there are, what kind of evidence exists. So there's two kinds of evidence. One kind of evidence we could say is evidence that is consistent with an account versus evidence that is dispositive of an account. And I've talked about this before in other videos, but this distinction is when we say evidence is consistent with an account, we means that the evidence doesn't contradict the account. That, well, looking at the evidence, what this person is saying could be true. Nothing about this evidence contradicts the defendant's story. Now, does that mean that the defendant's story is true? Well, no. It doesn't mean it's true legally, and it doesn't mean it's true factually. It just means that it's consistent, which means we can't rule out what the defendant is saying. On the other hand, dispositive evidence would be evidence that rules out alternatives, that rules out other explanations. I'll give you an example from the Michael Brown case. All of the gunshot wounds, there were multiple autopsies, and all the autopsies agreed that there were multiple gunshot wounds that entered from the front. So one that is consistent with Darren Wilson's account that he shot Michael Brown when Michael Brown was facing him, and it's dispositive. It rules out the claims of other eyewitnesses who testified that Darren Wilson shot Michael Brown as he was running away. It contradicts that story. So it shows that that story is false. So if I went back to like the Sam Harris video where I talked about Michael Brown, what a lot of people got upset about was I said, lacking video evidence, we don't know for certain what really happened. We have Darren Wilson's account that what happened was that Michael Brown grabbed for his gun and that he shot him in self-defense. Could that be true? Of course it could be true. Is the evidence consistent with that? Yes. But what is the evidence? Well, the evidence is Michael Brown's DNA is on the gun and Michael Brown's DNA is on the door handle, showing that he was, and there's foreign matter in Michael Brown's hand that is consistent with a gunshot wound, like gunshot residue. So what does that mean? Well, an expert from San Francisco who looked at it, what they testified was that that evidence was consistent with Darren Wilson's claim that Michael Brown grabbed for his gun and he shot him. But the expert who examined the evidence, and again, I am not a forensic analyst, right? But the expert who examined the evidence said there was also possible that it was just shot at close range, right? So his hand was in close range when he got shot. Does that mean that he was grabbing for the gun? Maybe. Sure. Do we know for certain? Factually? No. We don't have enough evidence to say factually. Now, I think that people might again, where people object and where people want to protest or protest to what I was saying, was they say, well, look at the Department of Justice report. Didn't the Department of Justice report clear Darren Wilson? Well, to some extent, because the Department of Justice laid out the legal standard for use of force. It talked about Graham versus Connor and reasonable force. And what it ultimately concluded, and again, we can get deep into kind of legalese, so I don't want to, but what it ultimately concluded was that the evidence was not sufficient to survive summary judgment. That they said that the evidence against Darren Wilson wasn't enough for the case to go forward. Therefore, they agreed with the grand jury's findings. Does that mean that they believe that Darren Wilson, what Darren Wilson said was literally factually true? No, they never said that. That's not the way that they would speak, right? That's not the way that lawyers talk. That's not the way that we talk about cases. We don't talk about what literally factually happened. We talk about our best understanding of it and whether it meets a certain legal standard. So when we look at the Darren Wilson case, we look at the Michael Brown's killing, this question about, well, doesn't the fact that he wasn't indicted by the grand jury, and doesn't the fact that the Department of Justice decided that there wasn't enough evidence for the case to go forward, doesn't that mean that he didn't do it? Well, it means that maybe he didn't do it. In fact, probably he didn't do it. I don't know, right? I'm not making a factual claim. All I said was that it hadn't ruled out the possibility, and that's true, right? Go back through the hundreds of pages of testimony and hundreds of pages of evidence. There's nothing about that rules out the possibility that maybe it wasn't Michael Brown grabbing for the gun, but that Darren Wilson had grabbed Michael Brown, pulled him in, and that's when the scuffle started, right? That's the only issue, right? That's the only issue that I'm calling into question, right? The facts, insofar as we understand them, are fairly clear, right? That Michael Brown was shot at close range, that there was a fight, that Darren Wilson was injured, that Michael Brown, after he was shot, ran away, that at some point he turned and started, whether he fell or started running is unclear, but at some point he turned and faced Darren Wilson again, and that's where he was shot again. What I'm trying to say is not one way or the other. I'm certainly not saying that Darren Wilson should have been found guilty. There's certainly not enough evidence for that. I'm not questioning the grand jury's findings. I'm not questioning the Department of Justice's report. All I was doing in the Sam Harris video, and all I'm trying to do now, is to point out that there's an ambiguity, that there's an uncertainty, and that kind of uncertainty is built into our legal system. That kind of uncertainty is not a bug, it's a feature. It's a feature of our legal system. That what do we do when there's uncertainty? We side with the defendant. What do we do if we're not 100% sure? We defer to letting the defendant go, declaring them innocent, saying that they should not go to jail and not be punished, because we presume innocence. When we let people go and when we find people innocent, we're not saying that we're not philosophers, right? And we're not scientists. We're not making those kinds of claims about the world. But we are as expressing the view of a democratic society as embodied in a jury. Think about, again, that juries are kind of weird, right? Like, that's not the way we find facts normally. We don't vote on facts. We don't vote on whether, is gravity negative 9.8 meters per second squared downward? Should we vote on that? Is the sun primarily composed of hydrogen and helium? Should we vote on that? No, we don't vote on facts normally. But when it comes to the law, we recognize that there's ambiguity. We recognize that there's uncertainty. We recognize that law is messy. And so whenever it's messy like that, we side with the defendant. And we say if there's ambiguity, it should be decided in favor of letting that person go. Because we're so terrified of the alternative, which is sending people who are factually innocent to jail. So thanks for watching. If you like this video and you'd like to ask a question that in office hours, please leave a comment, ask a question, and maybe I'll get back to you.